Is the Supreme Court about to let anti-gun states walk all over our freedoms? Or did they just deal the most devastating blow to the Second Amendment we've seen in a long time? In this video, we'll talk about the court's refusal to review New York's concealed carry ban on an emergency basis, why this refusal has many legal gun owners questioning the future of gun rights, and what we can do next to protect ourselves against what seems like open defiance of Supreme Court precedent. Before we dig into the details, I want to set the stage by explaining what led us here. Last year, the Supreme Court delivered a major Pro-2A victory with the Bruen decision, telling states they could not arbitrarily restrict an individual's right to carry a firearm in public. It was a momentous step toward restoring our constitutional rights. Yet New York decided to enact a new law just days after that ruling. They called it the Concealed Carry Improvement Act, or CCIA, which is really just a thinly veiled attempt to skirt the court's instructions. This law was even more restrictive, essentially making it impossible to carry in entire swaths of the state. That triggered legal challenges, which eventually made their way to the Second Circuit Court of Appeals. Unfortunately, the Second Circuit refused to block the law while litigation continues. In frustration, the plaintiffs sought an emergency intervention from the Supreme Court to stop the ban from being enforced until the case could be fully resolved. However, the court just turned them down, with all 9 justices refusing to grant the request. That was the bombshell that rocked the 2A community. On the surface, it might seem like the Supreme Court abandoned us. Many are wondering how we can trust the legal system when the same court that championed our right to carry in Bruen is allowing states to steamroll our freedoms. But there are important nuances in play. First, this is what lawyers call an interlocutory posture. That simply means the case has not been fully heard at the lower court level. Usually, the Supreme Court prefers to let the normal litigation process unfold. In other words, they often decline to step in on an emergency basis. That preference, however, doesn't make it any easier to swallow for people who are affected. When law-abiding individuals are denied their rights, even a short wait can feel like an injustice. We're also grappling with the fact that no justice chose to write a dissent. Not even Justices Thomas or Alito, who have previously been vocal about protecting Second Amendment rights. Some interpret their silence as a sign of strategic patience. They might believe that a bigger, more definitive ruling could be in the works, and they don't want to fracture the court by engaging in smaller skirmishes at this stage. Others see it as a lack of urgency. Either way, the immediate impact is unsettling because states like New York can continue enforcing laws that appear to contradict the spirit of the Bruen decision. This refusal to intervene is emboldening states to ignore or circumvent Supreme Court precedent. The key argument that New York has been pushing is that history from the late 19th century should be considered when analyzing whether a gun law is constitutional. That angle seems to undermine Bruen's emphasis on the founding era, primarily 1791, as the focal point for interpreting the Second Amendment. If New York is permitted to shift the historical lens forward by several decades or even a century, it might dig up older, more restrictive laws to justify its present-day bans. The big worry is that this approach could become a blueprint for other states to do the same, resulting in a patchwork of severe restrictions throughout the country. At this point, I'd like to know what you think. Do you believe the Supreme Court is simply exercising caution until the case is fully ripe, or are they letting lower courts run wild while our rights take the hit? Feel free to drop your thoughts in the comments below, because this fight is not just about one state. It's about every single American's right to bear arms, and we need to hear every viewpoint on how we should respond. One might ask, if the Supreme Court is punting on these important issues, does that mean they will never come back to them? Not necessarily. There are multiple gun-related cases moving through the courts right now, and some are in a similar procedural posture. Woolford v. Lopez, which challenges Hawaii's carry restrictions, is another example. Meanwhile, there are also ongoing battles about magazine bans and so-called assault weapon bans in cases like Duncan v. Bonta, Ocean State Tactical v. Rhode Island, and Snope, which challenges a rifle ban. Some of these have been relisted by the Supreme Court, meaning the justices are considering whether to discuss or rule on them in conference. A relist can be a sign that the court is taking time to craft an opinion or waiting for further input before making a decision. That could mean we'll see a major ruling that clarifies once and for all how Bruen should be applied, ending these maneuvers by anti-gun states. Yet there is a real risk here. While the Supreme Court waits for these cases to become final, States like New York can keep enforcing laws that drastically restrict carry. That's not a trivial inconvenience. Individuals who would otherwise be exercising a right protected by the Constitution are forced to choose between breaking the law or leaving their firearms at home. Anti-2A legislators, seeing that the Supreme Court isn't stopping them, may propose even more radical measures that push the envelope further. The court's decision to remain hands-off until final rulings come out is emboldening those anti-gunners. Law-abiding gun owners are caught in the middle. We're told to trust a legal system that recognized our rights in the Bruen decision but seems unwilling to defend those rights in the interim. Of course, there could be reasons behind the justices' silence. They may feel that addressing a case at this point, before the lower court has fully issued its judgment, is premature. Once the Second Circuit reaches a final ruling on the merits, there will be a more detailed record that the Supreme Court can examine. This is a standard judicial practice. The Supreme Court generally doesn't like to weigh in on preliminary injunctions unless there's something extremely egregious going on. The question is whether ignoring a law that effectively nullifies Bruen qualifies as egregious. It's important to remember that just because the Supreme Court declined emergency review does not mean it agrees with the Second Circuit's approach. The justices often stress that a denial of certiorari or a refusal to grant an emergency injunction should not be construed as approval of what the lower court has done. Unfortunately, New York and other states may see this as green light to push the limits, hoping they can get away with imposing more regulations while the legal battles grind on for months or even years. That's the infuriating side of this. We want immediate clarity, especially when people's constitutional rights are at stake. The court could be holding back because it's preparing to take on a bigger case, one that won't just deal with New York, but will also shut down every other state clinging to distorted or outdated versions of legal history to justify their gun control laws. Then again, maybe I'm just being too optimistic. If the justices issue a comprehensive ruling that lays down an unambiguous standard, it could stop these attempts to skirt Bruen once and for all. But can we afford to wait? The timeline is uncertain. Litigation can be a marathon, and in the meantime, gun owners in certain states are stuck navigating laws that violate the very decision the Supreme Court issued last year. What is also concerning is how New York has been defending the CCIA. The state contends that it's merely refining its licensing requirements in a way that's consistent with history. That argument, however, appears designed to expand historical analysis to eras far removed from the Constitution's ratification period, which was a core element of Bruen's framework. By citing laws from the mid to late 1800s, or even from the early 20th century, they aim to argue that there have always been restrictions. Yet the court in Bruen specifically emphasized the founding era as the most relevant period for understanding the Second Amendment. If this new approach prevails, it won't stop at concealed carry. It could influence bans on particular firearms, magazine limits, and storage requirements, among other restrictions. The Bruen decision shut down May issue permitting schemes, clarifying that the right to bear arms shouldn't be at the mercy of local authorities. Yet the fact that New York responded by doubling down on restrictions demonstrates how determined anti-2A lawmakers are to keep limiting our rights, regardless of Supreme Court guidance. It often takes multiple battles to cement the gains we've won in landmark decisions. The dissatisfaction we feel right now might turn into permanent success if the Supreme Court eventually issues a more robust ruling that leaves no wiggle room. The question is, how much damage will be done in the interim? We also have to remember we are not powerless while this process plays out. Organizations like the Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation continue to challenge these laws in court. Grassroots activism, too, can change the political landscape and affect how legislatures approach such issues. If enough of us show that we won't remain silent, elected officials may think twice about adopting measures they know could be overturned in a future Supreme Court ruling. Still, that requires sustained pressure, awareness, and a willingness to keep supporting lawsuits and lobbying efforts. If you're watching this and asking, well, what do we do in the short term? The reality is complicated. We can keep encouraging quick litigation strategies designed to expedite final rulings, so these issues can reach the Supreme Court on the merits. We can also shine a light on states that adopt restrictive measures, making it clear they are undermining constitutional rights. Above all, we need to stay informed, because these cases are continually evolving. One day, the court might decline to review an emergency injunction, but the next day, they could announce they're granting full review in another case that covers the same issues. Anyone telling you they know exactly how this will end is speculating. The best we can do is stay vigilant and keep pushing for clarity at the highest level. I don't see this as the final chapter in the battle for our rights. If anything, it's a reminder that securing liberty is an ongoing struggle. Anytime the Supreme Court takes a stand, those who want more restrictions will do everything they can to sidestep the ruling or reinterpret it to fit their agenda. Our job is to keep them accountable, which means we can't rely on a single decision to solve every problem. Bruen laid down a clear framework. The government bears the burden of showing that a firearm regulation is deeply rooted in this nation's history and tradition of firearm regulation at the time of the founding. When a court fails to apply that, or tries to shift the timeline to 50 or 100 years later, we have to call it out and seek higher judicial review. I also think this development underscores the importance of watching what happens in cases still under consideration. The Supreme Court might use one of the other lawsuits, like the challenges to magazine or rifle restrictions, to reinforce the message of Bruen. Once a final judgment is reached at the lower court level, the case becomes more attractive for the justices to take up. They might even combine multiple cases if they cover the same constitutional questions. If they are refusing emergency relief now because they want a solid, comprehensive record and a definitive moment to speak, then a future decision could be a profound reaffirmation of the right to keep and bear arms. But until then, the frustration in places like New York is palpable. People who genuinely want to follow the law are left in a bind while the details get hashed out in court. So, if the Supreme Court refuses to defend its own rulings, what's stopping anti-gun states from just ignoring the Constitution entirely? How far do you think they'll go before the court finally steps in? Comment below. Let's get a discussion going. And while you're down there, please like, share, subscribe, and click on the bell icon for more of these videos. Thanks for watching.